welcome to the March 2025 SHARP information session. In these sessions, we invite speakers to offer information sessions about resources, services, and tools available to help English-speaking seniors to age in the right place. My name is Erica Botner. I'm the program manager for seniors and the SHARP program at CHSSN. I'll be your facilitator for today's session. Today we have Richard Goldman from EDUCALOI, an organization that aims to explain the law in an easy-to-understand terms and enhance legal competency with the vision of promoting greater autonomy of individuals and communities in legal matters. They will be sharing valuable insights on how to handle lease renewal negotiations and what rights older adults have when facing potential repossession. So prior to joining EDUCALOI, Richard worked as a lawyer for Project Genesis, a Montreal-based community organization which advocates in the areas of housing rights and income security. He then served as coordinator of the Committee to Aid Refugees at the Volet Protection at the Table de Concertation des Organismes au Service de Personnes Réfugiées et Immigrantes. The acronym is TCRI. We're full of acronyms. Since May 2019, Richard has brought this commitment to social justice and access to justice for the vulnerable and marginalized through the service of EDUCALOI's mission. So I'm going to hand it over to Richard.
Thank you very much, Erica, and welcome everyone. And thank you for joining this webinar. So as Erica mentioned, this is being presented by EDUCALOI. So some of you may be familiar with EDUCALOI, others less so. So I'll just mention briefly, we are a nonprofit, independent organization. We're not part of the government, even though we do receive different types of funding, including government funding. Erica mentioned our mission to explain the law and their rights to Quebecers in an understandable manner. So if anything we do, if anything I do today is not understandable, please call me on it and I will try to make it clearer. Here you see our webpage. You can find us easily just by writing EDUCALOI in Google, or if you, the actual website is educaloi.qc.ca, but we're easy to find on Google in 2 seconds. Here you see the homepage of our website, and I'll just mention briefly that we have different sections. We have in the news sort of latest developments in the law, changes in the law, interesting court case or something like that. Law by topic, that's where you will find actually all the content that we're covering today and more in terms of rental housing. So you would click on that and look for rental housing. You'll find what we're covering today and many other things. Then we have web guides, which bring together content in a handy way. For example, there's a web guide for seniors, there's a web guide for caregivers, and so on. Publications is where you can get print copies. We have about 100 publications. I'm going to later on, Megan will put some in the chat that you can click on, but you can also order print copies of our publications. And because we are a nonprofit, everything is done free of charge. So for example, if you're with an organization that would like 50 copies of a guide we have on wills or on settling an estate or rental housing, then we will send it to you free of charge. The About, the last section in the menu, is where you can find out about the members of our team and more about our organization. And finally, you'll see the FR, because our website is almost perfectly mirror image, French and English. We have about 1,000 pieces of content, articles, videos, infographics, and so on. And you can toggle between French and English to get whichever version you prefer. If you do have questions about EDUCALOI, I'll be happy to answer them. I will mention also, we're not a legal clinic in the sense of a resource that you can call us and say, here's my problem, what do you think I can do? We provide information, but we don't provide individualized counseling or advice, which is why I won't necessarily be able to answer a specific, address a specific legal situation in this workshop. but we will be providing later in the presentation resources where you can get this kind of individualized help. These are some questions at this stage I just want you to think about, okay? We're going to come back to them later and give you the information you need that's relevant to answer. You're not expected to know the answer. And then we will look at the actual legal information that provides you with the answers. So here we go. True or false, again, just to think about for now. A landlord can ask for as large a rent increase as they wish. So think about that for now. Do you think a landlord can ask for as large a rent increase as they wish? Second one, true or false? A landlord can choose not to renew your lease if they're not happy with you as a tenant. So think about that. If the landlord is not happy with you as a tenant, can they simply say, I'm not renewing your lease? And last one to think about, true or false? If a tenant is over 65, a landlord can't repossess their apartment to move in. Okay, so again, you're not expected to know the answer. It's just to think about. By the end of this session, you will have the answers to all these questions and hopefully a lot more. Okay, so here we go with the actual presentation, lease renewals and rent increase. Okay, so one thing to keep in mind are most leases in Quebec, and if you have a lease, this is not new information for you. Most leases in Quebec are for 12 months and run from July 1st to June 30th, which is quite important for some of the deadlines and dates that we'll be looking at. So rent increases, a landlord can ask for an increase once a year. So even if, for example, you have a lease that, it's not that common in Quebec, but let's say you have a 6-month lease, your landlord can still only ask for one increase a year, okay? Now, what does that mean? Okay, so they have to give a notice 3 to 6 months before the lease comes up to renewal, if it's the typical 12-month lease. What does this mean in Quebec in terms of dates? So from that, the rent increase notice, if the landlord is going to send one for people who have the typical July to June lease, the sort of rent increase notice season is from January 1st to March 31st. So we're almost at the end of the season. So you might have the good fortune that you didn't get a rent increase notice yet, but you're not out of the woods yet because the landlords have until March 31st, if you have the typical lease, to send you the rent increase notice. And that means even postmark March 31st. They can go to the post office. If it's postmarked March 31st, even if you get it 2-3 days later, it's still considered a valid rent increase. The other part of this, if it happened to you already, it happened, and you've already experienced it, but people can be put in a kind of difficult situation because landlords can send the notice as early as the beginning of January. So you may get a notice 1 year, might have happened this year, but could happen next year, 5th, 6th of January, and you have to make a decision, fairly quickly what you're going to do. We're going to see in a moment how much time you have, but practically speaking means very early in the year, you could be put in the situation of having to decide what you want to do in July. This can be a little bit uncomfortable, but these are the rules. The landlord has from January 1st to March 31st for the typical lease to send the rent increase notice. Okay, so here is the first one. I asked you to think about it, and I'm now going to ask you, actually, I think we're launching a Zoom poll here to see what you think. And again, you're not expected to know the answer. It's just for discussion, okay? True or false, a landlord can ask for as large a rent increase as they wish. Okay, so we see that 81% say false. A landlord can, in other words, it's false that a landlord can ask a rent as much as they want, and 19% say true. So it's a little bit of a trick question and it turns on the word ask, okay? So a lot of you have, I think almost everyone has the right instinct that there is rent control in Quebec, so landlords can't get whatever they want. They can't force you to accept a 20% or a 30% increase. However, there's no limit to how much they can ask. Just as I could ask each of you, it's not illegal for me to ask each of you to send me $20 at the end of this presentation. It's, I might not get a very positive answer, but I'm allowed to ask. There's nothing illegal about it. However, there is a limit to how much the landlord will get if the tenant refuses because of rent controls in Quebec. What are your options? Okay, so a landlord can literally, like I say, ask anything. Let's say you're paying $1,000 a month. The landlord could ask 20%, could ask 30%, whatever they want. But you have three options. You can accept, you can always accept. You can refuse the increase, but renew your lease, that is, stay in the apartment. Or you can just decide that you're going to move out at the end of the lease. Now, one thing that some people don't understand, unfortunately, and sometimes landlords can be misleading about this in the notice that they send, is you do have the right to refuse, but stay in your apartment. And we'll see what happens if you do refuse. Sometimes landlords send a misleading notice that makes it sound like you've got two choices only, not three. Accept the increase or move out. Okay, so people have to understand that notice is actually illegal. So landlord is breaking the law if they give you the false impression that you have to either accept or move out. And it's very important for people to understand that you can refuse the increase, but renew your lease, that is, stay in your apartment. Now, answering the landlord, you have 1 month to answer. Okay, so that's very important. If you don't answer, if you don't do anything, you get your rent increase notice and you do nothing, then you're considered to have accepted. And if the landlord asks some crazy amount, like 20 or 30%, but you don't do anything, you're stuck with that 20 or 30% increase. So it's very important to know that you have to answer unless you're okay with the increase that's being requested. The best way to answer is by registered mail, so you can prove that the landlord got your answer. Now, if, for example, you live in a large building and there's a rental office, a permanent rental office that you can go into, you can save yourself the $12 or so of registered mail by making 2 copies of your answer and going in with these 2 copies and having somebody sign or stamp your copy showing that they received it. But otherwise, registered mail is the safest. Now, what happens if you refuse? The landlord has 1 month to file at the TAL. Now, what is the TAL? We're going to look a little more about it at the end, but that's the Tribunal Administratif du Logement, the Administrative Housing Tribunal. This used to be called the Régie du Logement until just a couple of years ago, or in English, the Rental Board. And in fact, in English, I think just about everybody still calls it the Rental Board. So I might use one word or another, either one term or another, either Rental Board or TAL, but it's, for our purposes, well, for all purposes, it's the same thing. Okay, so if you should refuse and say, I refuse the increase, but I want to stay in my place, the landlord has 1 month to file at the Rental Board. One important thing which a lot of people also don't understand is the tenant doesn't have to do anything. Like sometimes I've heard people say, I don't want to, refuse my rent increase. I'm going to have to fill out a bunch of forms. I'm going to have to file at the court. It's just not worth it to me. I'll accept a higher increase than, I think it should be, because it's just too much bureaucracy, too much red tape and paperwork. That's not how it is. The landlord has to do everything. The landlord has to file at the tribunal, and then has to actually, it's a heavy burden for the landlord in a way. They have to fill out some fairly lengthy forms which detail all the increase in their costs, their maintenance, their heating, if they are providing the heating, their taxes, and so on, and send out those forms to you and to the rental board, so you can see what the landlord's increases are. And then if nothing else happens, because we'll talk about negotiation in a second, but if nothing else happens, you don't reach any agreement with the landlord, then you'll be called to a hearing at the rental board a few months down the road. And again, the landlord has to do everything. If the landlord's asked for 7%, they have to prove with their costs, with details, with receipts, and so on, that their cost increase, the increase in cost justifies that 7%, and the rent increase will be based on their actual increase in costs. And you don't actually have to go to the hearing, but it's your right to go, look at every receipt that the landlord provides, and also dispute things. If the landlord says, oh, I renovated the front entrance, here's the bill for $10,000, and you say that's not true, no work was done on the front entrance, then the rental board will listen to what you have to say. And if they don't believe the landlord, then they will not take that supposed increase in cost, that particular item, into account. So you go to the hearing, you see what the landlord has to say. The landlord has to do everything, and you have the chance to inspect any receipts or bills that they produce and give your point of view. Now, it's also possible to negotiate, and in fact, it seems likely that the vast majority, or at least a very large portion of rent increases end up being settled with negotiation. How do we know this? Because the rental board only actually decides on about 20,000 rent increase cases a year, according to their statistics, whereas there's several million apartments in Quebec, all of them with some rare exceptions subject to rent control. So it would seem like a lot of cases are settled with negotiation, and landlords often are willing to negotiate because they have to do a lot of work to take a case to the rental board. But one thing to keep in mind if you're going to negotiate is your 1 month to answer the landlord. So it's wonderful to negotiate. Everything's great. If people can reach an agreement, that's wonderful, if it's satisfactory to everyone. But one thing to avoid is to start negotiating and back and forth, and then, oops, your 1 month delay is gone. It's passed. And then you can no longer legally refuse. So, what's the scenario? Your landlord asks for 10%. You say 10% is too high. The rental board, we're going to look at what the rental board's guidelines are in a moment. You tell them that that's higher than the rental board's guideline, back and forth, back and forth. Oops, a month has passed. You are legally stuck with that 10% increase. So the best way is refuse first and negotiate after to avoid missing the deadline. Now, what are the rental board guidelines for 2025? And this has created quite a bit of quite a bit of stress among tenants. These are guidelines that the rental board issues that they think on average, the rent increase should be for different types of apartments. Landlord may have higher or lower costs than the average, so it may not come out to this, but historically, the average increase granted by the rental board each year, because each year they publish these statistics, and then the year later they publish the statistics on the cases that went to the rental board. So historically, the increases granted have been pretty close to what their guidelines were. So you have to keep that in mind. So, and these guidelines I find very puzzling. So for unheated apartments, then of course we can't have actually unheated apartments in Montreal, unlike, maybe Florida. For unheated apartments, meaning heated by you, the tenant, it's 5.9%. If it's heated by the landlord, then you see it depends on the heating system. Electricity 5.5, gas 5.0, oil 4.1. These are quite puzzling, especially the fact that unheated is higher than heated, but it seems like they're basing it on each year on what was happening about a year ago, whether heating oil went down or up and so on, what the inflation was for certain things like maintenance and so on. So this is what they came up with, and it's quite a bit higher than last year. For example, unheated apartments is about double. So we're faced with this situation, unfortunately, and we're faced also with the situation that if you refuse, you're pretty likely to get something like that. So what does that mean? There's no right answer, to say, well, should I accept or should I refuse? Nobody can tell you that for sure, especially if you don't know exactly what the landlord's costs are. So the best we can do is to say, this is what you can expect if you go to the rental board. So, if you have an unheated apartment and the landlord asks for 10%, you're pretty safe in refusing and knowing that if it goes to the rental board, you'll get something less. But if the landlord asks you 6%, you're probably, unfortunately, going to get something like that. So it's up to you whether you want to refuse or not, of course, but you're probably going to get something like that. And if the landlord's costs are higher than the average, it might be more. Of course, if they're lower than average, it will be a little less. So unfortunately, there's not a lot of certainty here. It's not very clear, there's not very clear advice that anybody can give you. Yes, refuse, no, no, accept. The one thing I can say is, in general, you're pretty safe in refusing if the landlord has asked substantially more than these guidelines. So
I'll ask a question right away that came up for me and maybe came up for other people too. If you refuse the rent increase and the landlord takes you to TAL, I guess then you have a file open with TAL, and does that affect your reputation for future landlords, and if you're looking to rent somewhere new in the future?
Well, it's not impossible, because these files are public. So if, let's say you want to rent a new apartment, a landlord, your new potential landlord could, knowing your current address that you're living at, that you want to leave, and knowing your name, of course, could conceivably look up whether you contested a rent increase. It's not impossible. I personally haven't heard, but I mean, it's hard to know because, a landlord probably won't tip their hand. One problem with discrimination, not just because you've exercised your rental rights, but even other things, like if you have children or your ethnicity or whatever. One problem with discrimination is a smart landlord can always hide it, because there's an apartment shortage in most places in Quebec, especially in Montreal now. So landlords will typically get a whole assortment of people that they can choose, and they can choose one that they could say, well, this person has a higher income. I mean, they don't even have to explain to you, but there could be a lot of reasons that they choose one over the other that sound legitimate, like they have a higher income. Or I have a better feeling about them, that they won't damage the apartment. And unless they're stupid enough to say, you exercised your housing rights, so I'm discriminating against you, which could possibly be illegal, or even more dumb, like, well, I don't like people from your ethnic background, which you could, file at the Human Rights Commission. Unless they're dumb enough to do that, they can come up with, some excuse or some reason that you really can't criticize them on. So, I mean, I can only say I haven't heard from, working with rental housing for many years, people say that they know they were refused because they contested previous rent increases. But to answer the question as to whether it's impossible, it does seem to be possible that a landlord could actually look this up and choose prospective tenants, a prospective tenant who never contested a rent increase over one who did.
So what happens then if the situation, like if it goes to the TAL and it goes past the date that your new lease is supposed to start? What are you paying? Are you paying the old rent?
You're paying the old rent, and that is very typical. Okay. So let's look at this scenario. You refuse your rent increase today, okay? March 18th, the landlord files at the rental board sometime before April 18th, because they have a month. You may not get your hearing till September or October. So you've got let's say your rent is 1,000. You're paying 1,000. You're paying 1,000 July, August, September, October. Then you have your hearing and you get a 5% rent increase, say. That's $50 a month. You have to pay not only for every future month in the lease, but you will have to pay retroactively for the 4 or 5 months, $50 a month. So that's something that, and so there's obviously some risk involved in everything, like most things in life. If you knew today that you were going to get, let's say, I don't know, a 6 or 7% rent increase, you might choose to move out. I mean, it's a possibility if you feel you can do better elsewhere. But if you refuse, you won't know that till several months into the new lease. So you'll be stuck with that rent increase and with a retroactive payment for a couple of months. And that's just the uncertainty that's involved.
How does apartment maintenance requests affect rent increasement? Like if you're saying, oh, there's a leaky faucet or there's, plumbing
it shouldn't. It should not. That's considered part of regular maintenance. So the fact that you had a repair as opposed to your neighbor should not affect anything. It's one level of detail, I thought too many, but if there are major renovations, okay, then there is a separate formula that applies. So if the landlord put in 100,000 of renovations in your unit or the building, that will be added according to a different formula. But regular maintenance is caught in this whatever 5.9, 5.5, and the fact that you had 2 repairs and your neighbor didn't have any repairs this year will not change anything.
Can the landlord refuse installation of safety bars in showers or any other adaptive items?
I don't think so. I think there would. I'm pretty sure. I don't have that actual knowledge in terms of having ever checked that, but there are 2 reasons why they couldn't refuse. One is, as a general rule, you're allowed to install anything that, as long as you can restore the apartment to the original state, aside from normal wear and tear. So let's take a clear example that I know about. You're allowed to put a hole in the wall to put a nail or a screw, to hang a plant or put a painting, as long as you're going to plaster and cover and repaint that area. You're allowed to do that. So it should really be the same for a safety item like a bar in a shower. Another reason is it could be considered discrimination against a person with a disability if they refused, and that is illegal. So I'm quite confident that they could not stop that or punish you in any way for doing that. Here's the next pop quiz. So I asked you to think about. A landlord can choose not to renew your lease if they're not happy with you as a tenant. True or false? It's about 2 to 1 true, saying that a landlord can choose not to renew your lease if they're not happy with you as a tenant. So 2 to 1, approximately 2 to 1 say that's true. This is something that is a very, very important principle. The answer is false. The landlord cannot just say, Rick, you seem to be an okay guy, but I'm not happy with you as a tenant. I'm not renewing your lease. This cannot be done in Quebec. In Quebec, and I should maybe emphasize at the beginning, EDUCALOI, we present the laws that apply in Quebec, most of which are provincial laws like housing, like family law, wills, and so on. Some are laws that apply across Canada, like criminal law, but for housing law, we're showing you what applies in Quebec, which might be quite different from other places. And I know for a fact, just from general knowledge, that in many other places, a landlord could do this, could say, I'm just not happy with you, especially if it's a smaller, it's like a duplex or something. I'm not happy with you as a tenant. I'm not renewing your lease. Okay, so if some of you thought that, it's because that is the case in many places, but not in Quebec. In Quebec, tenants have a number of important protections. One of them, one of the most fundamental we saw already, is rent control. That doesn't exist everywhere. But here's another one, I would say equally important: automatic lease renewal. Okay, so what does that mean? If the landlord doesn't want to renew your lease, it's not enough to say, I'm not happy with you. They have to do two things. They have to find a legal reason. And we're going to look at one of the legal reasons later, repossession to move in. So they have to find a legal reason. And if you're not happy, I mean, if you don't agree, even though they have a legal reason, they have to get a judgment from the rental board. Okay? So not being happy with a tenant is not a legal reason. What are some examples of legal reasons? I mentioned we're going to look at one, which is repossession. Okay, and we're going to look at that. Another one, which we're not really talking about today, but if you have questions about it, we could talk about it. But a very obvious one is not paying your rent. You can be evicted for not paying your rent. In fact, you can be evicted for being even 3 weeks late in your rent. But even then, the landlord will have to get a judgment from the rental board. So again, at the risk of repetition, it's not enough for a landlord to say, I'm not happy with you as a tenant. This is not a legal reason in Quebec for refusing to renew your lease. And why is that? Because we have an important right in Quebec of automatic lease renewal. Now, this is an important protection for tenants, very important protection along with rent control. But it also means if you don't do anything, your lease will be automatically renewed. So, I mean, it's an important protection, but it also means you have to be aware that automatically your lease is renewed if you don't do anything. So if you're thinking of moving out, then there's two situations. Either you got a rent increase notice or you didn't. So if you got a rent increase notice, we already looked at this rule, so this is kind of reinforcing. If you got a rent increase notice, you have to give a notice within 1 month saying that you're moving out. If you don't do anything, you're stuck with another year on your lease, and you're stuck with the rent increase that the landlord asked for because you didn't do anything, you didn't refuse. Okay, so that's one scenario. You got a rent increase notice. The other scenario is if you're fortunate enough that you didn't get a rent increase notice, then it's up to you to do something. You have to give a notice at least 3 months before that you're moving. Okay, so what does this mean? Here we are, March 18th, right? You haven't received a rent increase notice. So good news so far. But in any event, you want to move out. Doesn't matter what the rent increase notice is going to say, you've decided you want to move out. You want to live somewhere else. You have to make sure to send a notice to the landlord by March 31st saying you're moving out. Okay? If not, even though you're lucky enough not to get a rent increase, you will be stuck with another year on your lease, which is a nasty situation if you wanted to move out. Okay, so we've looked at two very, very important protections for tenants in Quebec: rent control and automatic lease renewal. Okay, so now let's say you want to get out of your lease in the middle of the lease. Okay, so we talked about if you decided that you want to leave June 30th. Okay, so here we are, March 18th. You decided you want to leave June 30th at the renewal. You have to make sure, as I just said, to send your notice by March 31st, saying, I'm moving out, I'm not renewing my lease. But let's say you want to end your lease in the middle. Let's say it's September or August, and you just got a job out of town, or you want to go, whatever, retire out of town or go to school out of town, whatever. You do have some options, basically sublease and transfer. What's the difference? Sublease, you can come back after. So that would be like you want to, travel for 3 months or something, but you don't want to give up your apartment. So good point, you can come back, but negative point, you remain responsible for the rent even while you're away. So you sublet to somebody, they don't pay the rent, they skip out, you left for 3 months and you sublet for 3 months, you will have to pay those 3 months rent, or the landlord could cancel your lease. Transfer, you can't come back. This is like, that's it. You're giving up your lease, you're giving it to somebody else. So you can't come back. That's a negative point. You can't change your mind. But good point, you have no further responsibilities. So if the person you transfer to doesn't pay the rent, it's not your worry. They will get evicted, but you don't have to pay any of their rent. There was a change in the law about a year ago. Landlords can refuse a transfer without giving any reason, in which case the lease ends at the date of the proposed transfer. So let's say you have somebody in mind that you want to transfer to. Your rent is good, so you're kind of doing them a favor. The landlord can now refuse. You'll still get out of your lease. You'll be able to move out of town or do whatever you want, but you can't. You lose the benefit, or the person who you transfer to can't get the benefit of getting your apartment at, let's say it's a good rent, which is why they wanted to have it. The procedure is quite simple. You send a notice 15 days before the transfer or sublease is supposed to take effect, with proof that the new tenant can pay the rent. Okay, and for a sublease, the only reason the landlord could really refuse is if it's not true that they could pay the rent, like the landlord looks at their income and it's not realistic for paying the rent, or if the landlord does some research and finds out, for example, they damaged another apartment, they were evicted for damaging another apartment or not paying their rent, that would be a reason. For transfer, as I mentioned, now landlord doesn't have to give any reason. They can just say, I don't want you to choose the tenant. I'm going to choose the tenant, but you still get out of your lease. So you accomplished what you wanted. You managed to get out of your lease in the middle of your lease. Okay.
I'm going to ask a question, and maybe that'll get the ball rolling, about the transfer. Can that happen at any time during the lease? Or
that's specifically why you would do it, that it could happen anytime during the lease. So if, for example, you want to move June 30th, there's no reason to transfer. You just end your lease if it comes up for renewal June 30th. It's more the scenario like it's September, it's October, something has come up, you want to be out of town for a few months, or maybe you want to buy a house or whatever, and you're taking possession of the house February 1st, so there's still 5 months left on your lease or whatever. That would be the scenario where you sublease.
Okay. And so if you find someone to transfer it to and they refuse it, you can still get out.
Yes. Yeah, you will still get out of your lease.
Okay.
Okay.
Perfect. Somebody just put in the chat, what is the duration again, please? But I'm not sure exactly what they're referring to. Is it the duration for?
Yeah, maybe they could clarify. I'll just say there's no, for the sublease, there's no specific limit, but maybe it's too much detail. But if you actually sublet for 2 years, the landlord, and you didn't come back, the landlord could cancel the lease. For transfer, it's forever, because the new tenant is basically just taking over from you. We'll move on to repossession. So what is repossession? Before I ask you the pop-up quiz question, what are we even talking about? So a landlord can repossess, that is, take back an apartment to live there themselves, have their children or parents live there, or have any other family member or relative by marriage live there, if the landlord is the person's main source of support. For example, a nephew, a mother-in-law. So for the parents or children, the landlord does not have to prove they're supporting them. But for another relative, again, nephew, mother-in-law, whatever, they would have to prove they're actually supporting them. And if it's to live there themselves, well, then there's no issue of support. They're just moving in themselves. So how is it done? It requires a 6-month notice before the lease ends. So this is a longer notice than the rent increase. The rent increase could be as little as 3 months. So like I said, even March 31st, your landlord could still send you a rent increase notice for the typical July to June lease. This is a longer notice. It has to be 6 months. So if your lease is ending June 30th or coming up for renewal June 30th, and you didn't get a notice of repossession this year, you're in the clear. It's too late. Your landlord can't do it. Okay, they would have had to do it by December 31st. Let's say they did do it. Now it's like it's already too late, but let's say, December 15th, you got it, or you get it next December 15th, then you will have 1 month to respond. And if you don't respond, it means you refused, which could be a little confusing. It's very good that if you don't respond, it's a refusal. It's very good for you as a tenant that, if you don't do anything, you're considered to have refused. But it could be a little confusing because if you don't answer a rent increase notice, you're considered to have accepted. But if you don't answer a repossession notice, you're considered to have refused. So maybe it would have been better if the law said, anytime you don't answer, it's a refusal. Anytime you don't answer, you accept. I don't know. That could be debated. But in any event, for repossession, no response means refusal. If the tenant refuses, the landlord must apply to the TAL, just like a rent increase, for permission to repossess and show they really intend to use the apartment for the reason mentioned, to move in themselves, to move in their son, their daughter, whatever, and they're not planning to re-rent it to someone else to boost the rent. Okay, and this usually means that whoever is moving in has to come to the rental board and testify and say, I'm moving into this apartment downtown in Montreal because I'm going to Concordia and it's very convenient or whatever. But if the daughter in question lives in California and there's no indication that she's moving back to Montreal and she doesn't even come to testify, the TAL could decide this doesn't look genuine and can refuse it. Now, if it is granted, normally you will receive compensation for your moving costs and possibly additional compensation. For example, if you live there a long time, you have other considerations, you have a disability or whatever, it's hard for you to move, you're elderly, the TAL could give you additional compensation that the landlord has to pay you. So here's our pop quiz. True or false, if a tenant is over 65, a landlord can't repossess their apartment to move in. Slight majority said it's true. The answer is it's mainly true. In other words, it's in a lot of situations it will be true, but not in all situations. So a landlord cannot repossess if the tenant or their spouse meets 3 conditions. So there are several conditions, these 3 conditions that have to be met. So the 65 years or older, that's an important condition. And that's probably a lot of you heard something about that. And you're right, that's an important factor, being over 65. You don't get any of this protection if you're under 65. You have to have lived there 10 years or more. That probably applies to a lot of people. But you have to also be, I wouldn't even say low income, but medium income that is not high income. So there's a formula, and I'm going to, the formula doesn't make much sense just from reading it. You have to have an income that's no higher than 125% of the maximum income to get into low-cost housing. What is that amount? Okay, it's like you have to do a tiny bit of research to find out what that amount is. It's $50,000. So if a single person or a couple, for some reason it's the same 50,000, has 50,000 or less, they meet the income requirement. So let's summarize: 65 and over, live there for 10 years or more, has an income $50,000, whether it's single or a couple, of 50,000 or less, then you're protected. So a lot of people will benefit from this protection. So that's why I think you're right by, most of you, slight majority said that this protection exists. But even then there's an exception if the landlord themselves is over 65 or they want to house a relative over 65. So even if the landlord's 45, but they want to move in their mother who's 70, then this protection doesn't apply. So it is an important protection for many people. There are a number of criteria, and there's even an exception for if the landlord is elderly or is moving in an elderly relative. This is other reasons why a landlord wouldn't be able to repossess. Okay, aside from this 65 and over, other reasons If the landlord happens to have a similar size apartment nearby with a similar rent, they can't, if it's another apartment that's similar is coming up for renewal, and the tenant is moving on June 30th, they can't choose to kick you out of your apartment instead. The building is owned by a company, so especially larger places owned by a corporation, they can't do this. The landlord, the owner, has to be a physical person. A company can't say, well, I want the president, we want the president's daughter to live in this. It doesn't work like that. It's owned by a company. Or an even more unusual situation, two friends buy a duplex together. They can't repossess either unit. This was something that Quebec was a little concerned about maybe a couple of decades ago, that a lot of young couples were buying up duplexes and triplexes at the time emptying them to move in. That's not possible anymore. It has to be just one person or one couple that buys the whole building, and then they could move into one of the units.
Can a landlord repossess if they want to sell the property?
No, absolutely not. It's to actually live there. Actually, I recently saw a case where repossession was refused because the landlord was simultaneously saying he wanted to move in and had it on the market to sell. So the rental board said, well, what are you talking about? You're saying you want to move in, but you're actually trying to sell the place. This doesn't make sense, and they refused it. So they cannot, I mean, a smart landlord might get away with it by doing one, moving in, and then, a year later selling it, but they can't do both. They can't, and especially if they're actually admitting that or openly doing both, it's not going to work.
Mm-hmm.
So eviction for major works, this is a good news thing. Now, this is a special meaning of eviction. Like eviction, again, this, some things, some legalese is a bit a bit confusing. Eviction, most people think you get kicked out of your apartment for any reason, for example, not paying your rent. But this is a specific type of eviction for major works. And as of June of last year, and for 3 years, landlords can't evict a tenant to subdivide a rental housing, enlarge it, or change its use. For example, changing it into an office or a store. This was an important right that landlords had, and it's suspended for 3 years. So you can't be kicked out if your landlord wants to make your building commercial, or you have a ground floor apartment on, a nice street where there's stores and they want to make your apartment into a store. That can't happen for 3 years. So that's good news. And the very last thing is just touching on the Tribunal Administratif du Logement, the rental board. What can they offer you? Information. We have a lot of information. I showed you where to find it on rental housing at EDUCALOI. Rental housing is really the only thing they do, so they have a very extensive website in English and French with information about different aspects of rental housing that goes beyond what EDUCALOI has. There's also forms, for example, okay, if you want to refuse a repossession or a rent increase, whatever, you can write a simple note saying, I refuse the rent increase, but I want to remain in my apartment. That's perfectly legal. But if you prefer to have a prepared form, they have a form that you can download for just about everything, including the examples I gave. If you want to start a case at the rental board, the situations we saw were basically today, repossession and rent increase. It's up to the landlord to start the case, but maybe you want to start a case for repairs, for example, they will help you to start it. And the very last thing are some resources. EDUCALOI, the tribunal itself. If you're in Montreal, Project Genesis, where I used to work on housing rights. Now, one network that's very helpful is Comité Logement, housing committees. They're all over Quebec. You'll find this information in the info and referral guide also, so you don't have to go crazy writing it down, but there it is. That's where you can go and maybe sit down with someone and discuss your rent increase or discuss another individual situation, repair or whatever. Centre de Justice de Proximité, community justice centers. This is something relatively new in Quebec the last few years, where you won't get legal representation like at the Quebec Legal Aid Office, but you can sit down with somebody and again get information, not just about housing, but family law, successions, a lot of legal areas. There's the McGill, it just says legal information clinics, actually the McGill Legal Information Clinic. They're here if you're in Montreal. The Young Bar of Montreal, if you're actually facing a hearing at the rental board, they can help you to prepare. And if you have a complaint regarding a private seniors residence, there's a specific complaint commissioner who can help you with that. And again, all of this is in the guide that you'll find at the link in the chat. So that's the presentation. So now is any other questions?
Can a landlord refuse if I want to add a partner to my lease? Do I legally have to ask for them to come on the lease?
No, there's many illegal clauses that you see landlords sometimes try. One of them is saying you're not allowed to live with anybody else. The only restriction on the number of people is if it actually becomes a threat to safety or security. So you rent a 1.5 and then like you invite 7 roommates to live with you, that would be considered you know, a threat, like unsanitary and a threat possibly to health or safety. But simply having a partner, that couldn't be a reason. The same thing, having a child wouldn't be a reason unless, you know, it's a 1.5 and okay, you have 1 kid, you're a couple with 1 kid, pretty crowded, but I don't think anyone would consider it a threat to safety or health. But if you had 1 kid every year for 7 years, probably yes.
The next question was, can a landlord evict a 68-year-old tenant with an onset of dementia? So somebody, you know, if there's already a diagnosis of cognitive impairment.
A disability per se is not a reason if there is if there is an actual legal reason. So let's take a couple of examples. This person, you know, has a condition, it's not their fault, but they're not paying the rent. And whoever is taking care of their affairs, whether it's through a protection mandate or a tutorship, is not paying their rent. That is like, that will not protect them. You still have to pay your rent. So so maybe we need more information. If the question is this a protection against eviction for all reasons? The answer is definitely no. If the question is, can you evict someone because they have dementia or because they have a disability? It's absolutely not. It would be discrimination, which is protected not so much by rental laws, but by the Quebec Charter of Human Rights. Another important protection, general protection in Quebec law for tenants, is even if a clause is in the lease, but it's an illegal clause, it just has no effect. So what would be an example? You can't have a spouse move in with you. Completely illegal. Another would be, we didn't talk about repairs, but let's say a clause that says the tenant is responsible for all repairs, regardless of the reason. Or one that we talked about today, the tenant cannot transfer or sublet. These are all illegal clauses, and even if they're in your lease, you can ignore them.
Years ago, the landlord added to my lease that if anyone moves in, he automatically raises the rent by $50.
That's completely illegal in Quebec. Completely illegal. So you can ignore it. And if the landlord tries to take the case to the rental board, I don't see how they could succeed.
Can a tenant operate like an Airbnb and make money off of it if they're renting?
That is generally considered to be a commercial lease, a commercial activity, and it's changing the use of the apartment. So generally that cannot be done without the permission of the landlord. Basically, just like if the landlord wanted to make your apartment into a store, you know, they can't just go ahead and do it. But on top of that, there are a lot of restrictions, at least in Montreal. I'm not sure if, I think of certain ones across Quebec, and Montreal is introducing even more in terms of registering Airbnbs, proving that you have the landlord's permission. So, okay, I should nuance it a bit. If the landlord is okay with it, then you still need to get permission or registration from Quebec. If the landlord is not okay with it, then it's changing the use of the apartment, and I think it could be a cause for eviction.
Okay. Do you have any tips for seniors on fixed incomes who may have to move with today's rent prices, because of today's rent prices?
Well, the one really obvious thing, but and I can't tell you how long the waiting list is now, is for government low-cost housing.
Mhm.
So the resource for that, the main resource for that are the housing committees that I talked about before. They would be, or you could contact directly for your municipality, for example, for Montreal, the Office Municipal d'Habitation, but every municipality has one. Project Genesis, if you're in Montreal, they're a good resource for information about low-cost housing. The other things but it's not much of a help, it's a little bit of a help, is there's the allocation logement, but I think it gives just like $60 a month or maybe $80 a month maximum. So it doesn't help if your rent is getting really close to your fixed income. And there are a number of credits for seniors, especially caregivers and so on your income tax, and that's a little bit beyond my level of expertise. So you would talk to a tax clinic about that.
Can you move out of an apartment during the year if you give 3 months notice prior?
Okay, that's an excellent question, because a lot of people think that, and maybe it's the rule. One thing is that makes things complicated or confusing is the rules in Quebec are very different than other places. For example, I gave one of the pop quiz example. If the landlord is not happy with you, can they just not renew your lease? In some places, that's the case. And Quebec, we have automatic lease renewal. We have a strong protection. So it is possible that in some places with a sufficient notice, for example, 3 months, you can end your lease. That's not the case in Quebec. The options that you see here, well, there are some other options which we didn't get into. For example, if you are admitted either to government low-cost housing or to a senior's residence, you can end your lease with 2 months' notice. We didn't get to that level of detail, but that is a possibility if you are accepted either into government low-cost housing or seniors residence. And even there's another one, if due to a disability. So for example, somebody mentioned the person with dementia. If they're no longer able to occupy their apartment due to their dementia, they could benefit, even if they're not admitted to a seniors home. Let's say they're going to move in with a relative who will be their caregiver, but they're not able to occupy their apartment due to this disability. They can end their lease with 2 months' notice. So there are some situations, but there's not a general rule that allows like anyone who has no particular disability or not admitted to low-cost housing. There's no general rule that says I can end my lease at any time, giving 3 months' notice.
At the end of a lease, can a landlord charge you to fix up the apartment for a new tenant?
Not to fix up, but let's just, I'll go back to something I said before. You have the obligation to restore it to the state it was in, except for normal wear and tear. So what does that mean? If you put 5 paintings up in your living room and each one has a hole, you probably have to plaster and probably have to repaint. It is fact specific. So if the paint was faded, like there's no one rule. If the paint was 10 years old and it would have had to be painted anyway, you don't have to refresh the apartment. But if you moved in last year and the landlord freshly painted and now you've got these 5 holes that you plastered over, the landlord could say, look, I don't have to, I shouldn't have to paint every year. This is not normal wear and tear. You have to repaint. So the rule is you have to restore it to its previous condition minus normal wear and tear, but it's very fact specific as to what is normal wear and tear.
Excellent. Thank you so much. So a lot of really great information for all of us. Some things we know and some things that were surprising as well. Well, I think we've come to an end of the questions, and I just want to give a huge thank you to Richard. A very informative presentation and Q&A. And yeah, I'll just encourage you to share what you learned here with somebody else, because that's how we pass on the knowledge, and being more aware of our rights as tenants is going to help you to be able to age in place. So
Okay,
thank you
terrific.
again, Richard. We appreciate our collaboration with EDUCALOI as always, and we'll see you at the next session.
All
Okay.
right.
So
Enjoy the
thanks,
spring, everyone.
everyone. Take care.